Welcome to another Bearded Wonder Explains. This time we're going to talk about major Supreme Court cases. There's going to be quite a few of them, and you're going to need to kind of summarize all of these because you do kind of need to be familiar with them and what they argued. So make sure that you take some notes on why each one is important. And we're kind of looking at these decisions over time. Trying to understand exactly how the Supreme Court has defined certain things related to the Constitution and power and how things work. The first case that we need to be aware of is called Marbury versus Madison in 1803, and this was basically the first case that came up that asked the question of when different people disagree on what the Constitution means, who decides what it means? And the Constitution doesn't specifically say that the Supreme Court of the United States is the ultimate decider. It's kind of sovereign over those things. And Marbury versus Madison argued that was the case. Now, we should notice from the very beginning that this is basically everybody saying that they get to make the decision, and then the judiciary is just one of those many different groups of people, whether it's the people or the states or the president or the Congress. They're just one kind of part of our government. But basically everybody else over time has agreed that that's the case. And so we established this principle of what we call judicial review, which ultimately says that in the American government, the Supreme Court makes the decision. We call it judicial review. Settled in 1803 by the judicial branch, saying that the judicial branch is in charge. The next important case that you need to be aware of is McCulloch versus Maryland, 1819, and basically the argument in McCulloch versus Maryland was that the issue of federalism, right? The state said it was specifically about a bank, and Maryland argued that there could not be a national bank because the Constitution didn't give the power to the national government to have a national bank. The Supreme Court ruled that it kind of did and kind of didn't. And that because it gave the national government the job to regulate commerce, and banks are a part of that, that even though it doesn't say bank is still kind of okay because of other things that the Constitution does say, which is basically Alexander Hamilton's argument. He had been dead at that point for over a decade. But basically, McCulloch versus Maryland argued that the national government is sovereign over the state governments. Ogden versus Sanford reinforced the same idea more broadly. And so you can kind of combine those two together. They're sort of resolving, at least from the Supreme Court perspective, this idea of national supremacy, that the national government is supreme to the state governments. By the way, just because the Supreme Court says something doesn't mean that they get it wrong. Plessy versus Ferguson, the Supreme Court said that separate and equal was okay. And so we're definitely in situations where the Supreme Court has gotten things wrong. Speaking of getting things wrong, we have the Dred Scott decision in 1857. Dred Scott was an enslaved man who had been taken to several free states, and he argued that the state laws, when he was taken across into those boundaries, actually made him a freed man because he was a slave in a state that did not allow slavery. The Supreme Court basically argued that the Constitution basically got around all of that. The states argued that, yeah, but they didn't have to have slavery just because the Constitution says so. McCulloch versus Maryland, the precedent said that, yeah, actually you kind of do. And so the decision was made that slaves cannot sue in federal court. They have no standing in federal court is what that's called. And also that slavery is a nationally protected law. It was literally in the Constitution that if you are a slave and you have escaped, that you had to be returned even if slavery was illegal in one of the other states. And so the Supreme Court got it right from the perspective of that's what the Constitution said. They got it wrong from the perspective of the Constitution should not have said that, right? The Constitution was wrong in the case of slavery, or at least as a 21st century American, that's what I would say. But it does call attention to the fact that technically speaking, the Supreme Court is supposed to interpret the Constitution as it's written, not maybe what they would like it to say. However, that doesn't always work, and we have situations like Texas versus White in 1869, which was really trying to resolve this issue of whether a state could secede or not. This is after the Civil War, and everybody kind of accepted that the Civil War had decided that states can't, or at least in that case, that the states couldn't secede because they lost. But that doesn't mean that they can't legally secede. That question was never really answered. And so basically the Supreme Court justice said in one of his rulings that states can't secede. And this kind of introduces this idea, and we'll unpack this idea a lot more with a specific example in another video. But there's this thing called precedent. And basically precedent is super important in the way that our laws are built. And basically the Supreme Court oftentimes, to explain what the Constitution means, it actually looks at what the Supreme Court has said in other cases. And so in this case, the Supreme Court justice basically just said secession's not okay in the United States. There's no laws, and the Constitution doesn't actually say that. It doesn't say that it's not either. It doesn't say really anything about the issue, and that was the problem. But when he said that, from that point forward, every Supreme Court, like anytime secession comes up, they're going to say, oh, well, in Texas versus White in 1869, this justice said this, and because that was said, and because that's the decision made by the people in charge, Marbury versus Madison, that's what it is. And so that's kind of how the Supreme Court can make laws without making laws. We have Sparf versus the United States in 1895. Prior to that, juries basically had the ability to declare laws unconstitutional. So you could be brought before a jury, a national jury, and they could charge you with the case, and they could say these are the facts, and the jury could basically say, well, we believe that the person did everything that the prosecutor says they did, but we're going to find them not guilty anyway because we think that this should not be a law. It was literally a way for juries, for the people, to cancel laws. And there was a lot of faith put in those 12 people, but it normally worked out. Federalists and anti-federalists kind of saw this as the ultimate restraint on the government's power. But in Sparf versus the United States, what ended up happening was the Supreme Court ruled that juries could not do that, that from that point forward, they could only rule as to whether a person did what the prosecutor says they did or not. And that any questions had to be addressed by the judge as to what the law meant. That juries were not allowed to actually rule on whether a law itself was constitutional or unconstitutional. The next important case to be aware of is called Schenck versus the United States. It's a free speech case. Basically, Schenck was an author, and he was arguing in 1919, basically based on the Civil War, or sorry, the World War I, that citizens should rise up and should overthrow their government, that the government didn't have a right to be doing some of the things it was to fight the war. And essentially, what ended up happening was the Supreme Court ruled that freedom of speech is limited. In other words, there are certain things that you are not allowed to say, and that the freedom of speech clause of the First Amendment does not mean that you can say anything. You can just say most things. And who gets to decide what the most things are? Well, of course, it's the Supreme Court. Next law to just kind of be aware of is Brown versus the Board of Education. They ruled that basically that overruled Plessy versus Ferguson, which isn't on this list here, but was in 1896, I believe. But basically, Brown versus Board of Education canceled a previous Supreme Court rule and went the opposite direction, saying that separate is not equal. But it also then said that the government has to ensure that everyone has equal accommodation, specifically in this case in education. But that principle would then be applied to all kinds of stuff like people with disabilities and other things like that. Engel versus Vitale is a very important Supreme Court case for you as a student. It ruled that all religion and anti-religious practices by school officials violate your First Amendment rights. In other words, you cannot be forced to engage. In this case, it was in a Christian prayer. And so during the moment of silence in 1961 in Pennsylvania, which is where this lawsuit came from, they would do a prayer instead of just a moment of silence, and the teacher would literally lead a prayer and everybody would stand there quietly while the prayer was happening. They ruled that that's unconstitutional. That's the government, through a public school, a government school, forcing religion on students. Also ruled that they cannot force you to be not religious. In other words, if you have religious perspectives or beliefs or ideas, that the school cannot prevent you from saying those either, although it did say with an asterisk on that, unless it's disruptive to the learning environment. And what disruptive means was clarified by other court cases. Next one talked about a lot in our society is Roe versus Wade in 1971. Roe versus Wade found that states cannot restrict abortion in the first trimester. Now, important again to recognize, because a lot of times people talk about abortion and they talk about Roe versus Wade as though it made all abortions illegal. Roe versus Wade actually did not do that. If you read the court case and you read what the justices said, it says that a state cannot restrict access to abortion in the first trimester. It said that it has to be done by a licensed physician, that's a decision based on privacy between an individual and their physician, but that the state can decide who gets a physician's license and not. Roe versus Wade also argued that states have a legal obligation to protect the rights of the fetus after what it called the age of viability. Now, it didn't define exactly when that was, but the age of viability is this idea that basically if you removed a fetus from the mother's womb, if it would survive, that's the age of viability. And Roe versus Wade found that that was when states had kind of an obligation to protect the rights of they would have said that person. Again, you're not required to agree with this. There are many people who believe that abortion is wrong at any age, even in the first trimester. There are others that believe that abortion rights should continue past the age of viability. That's not really the issue or the point of this video. This video is just pointing out what that court case said and what it doesn't say. And finally, Heller versus the District of Columbia, often referred to as just the Heller case in 2008, basically found that all citizens have a right to own certain guns, although not all guns, and to use them in self-defense in their homes. It also upheld this idea that the Second Amendment doesn't give you the right to own an Apache helicopter and surface-to-air missiles. In other words, that there was a limit to the Second Amendment. All of these cases basically deciding that the government, and specifically the Supreme Court in the government, has the ultimate say-so in all of these cases. Whether it's the First Amendment, the Second Amendment, whether it's whatever, we have to go back to Marbury versus Madison, 1803, where the Supreme Court basically said that the Supreme Court gets to decide what the Constitution means for everything, and that's kind of the last word. And all of these other groups, the people, the states, the executive, the legislative branch, even the Constitution to some degree, are controlled by whatever the Supreme Court says it is. And so that's just an overview of the important Supreme Court cases. Make sure that you're kind of aware of them. I would actually study kind of the bullet points here to understand why each of these is significant, but also understand kind of how the Supreme Court over time has defined different issues in the Constitution as being up to what they say it is. Because it's a really important concept to understanding how the government works today. And understand that that all started 1803 with this concept of judicial review in Marbury versus Madison. Thanks for watching. Hope you have a good day.